Oh, there we go. Okay. All right, good afternoon. I'm calling the City of Titusville Special Magistrate hearing to order for March 11th, 2024. Time is now 2:03. I do have a bit of an opening script to read, so I will go ahead and do that. These are public hearings for code enforcement violations. The hearings are quasi-judicial, and I am the special magistrate appointed to hear these cases. Formal rules of evidence do not apply, but fundamental due process shall be observed. Everyone who has a case today will have an opportunity to present testimony. You may present evidence and/or witnesses to testify on your behalf. There is no public comment portion. You must be a respondent or be called as a witness in order to speak on a specific case. Everything today is being recorded and all testimony will be under oath. When you are sworn in, please provide your current mailing address so any orders get to the correct address. The city will present its case first and information will be displayed on the screen. Documents may be provided by the city as evidence. The city's PowerPoint presentation will be entered into evidence unless objections are made. After the evidence is presented, I will make a ruling. That ruling will be reduced to writing in the form of an order and will be mailed to you. I will go ahead and swear in witnesses. So if you intend to speak to me today, please stand, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth? If so, please say I do.
I do.
Thank you. You may be seated. And I'll just add that any orders that are entered today can be appealed by sending a notice of appeal to the circuit court within 30 days after the execution of my order. So I'll just make that preface statement as well. All right, we can get to the hearings. First one we have is a Massey case, 24-01, Titus Holdings LLC.
Yes, ma'am. Good afternoon.
Good afternoon.
I'm happy to report that that particular case has been brought in compliance as of 2/6/2024, and the magistrate had ordered costs into the city, which have also been paid, and if we could just get an order of compliance in that case.
All right. And so you would like for my order to provide that there is no fine, but still impose the costs of prosecution?
That have been paid.
Oh, they've already been paid?
Yes, ma'am.
Okay, all right, thank you.
Thank you, ma'am.
All right. Yes, I will find that the respondent in this case has complied with the the special magistrate's prior order by the date specified in that order, and no further fine will be imposed. Thank you.
Yes, ma'am. Our next case
Yes?
is 24-06, Space Coast Petro Distributors. That's also a Massey hearing, and that was with Officer Kyle Mack from the fire department, who has stated that that too is in compliance as of today.
Okay. And so that was, remind me, the date was for March, or that was for today, correct?
Yes, ma'am.
The date was March 11th at noon. And so it has come into compliance. And again, are you asking me to still have the cost of prosecution in the order?
Yes, ma'am. We would still want the cost.
Okay, all right. All right, then I find that respondent in this case has complied with the special magistrate's prior order by the date specified in that order, and no fine will be imposed. However, the cost of prosecution shall remain and shall be imposed as set forth in the special magistrate's prior order.
The city attorney's office requests that you just find that the words imposing costs are in the title of that order.
Okay.
Thank you.
Okay, next case.
Yes, ma'am. This is case number 24-09, C-Cube's Landing, also a Massey hearing. That particular case, at the last initial hearing, two of the violations were supposed to be brought into compliance by today's hearing, and those are the only ones that we're referring to today.
Yes.
And the officer is Jim Flanagan, who is here, who will provide his evidence and PowerPoint in this matter.
Okay. Go ahead.
Good afternoon. Again, yes, this would be 3304 South Hopkins Avenue. Reference the massing hearing. I have a notice of affidavit for today's hearing for you.
Okay. Thank you.
Okay.
And yes, I'll admit that as Exhibit 1.
Okay.
Thank you.
And this would be the respondent, which is the property C-Cube's Landing LLC. The violation address 3304 South Hopkins Avenue. And the mail-to address is 5155 South Washington Avenue, Unit 203. And today we're discussing the business tax receipts requirements and the running water. The notice of respondent was mailed and certified and first class mailed on February 14th, and a notice of hearing was posted at City Hall and on the property as February 26th, along in the first class mail for the hearing as well.
Okay.
There's been no contact with the owner since. I texted him and emailed him the information as well as mailings, and have had no contact with him for today's hearing. This case was originally heard on February 12th. The respondent was ordered to correct the violations by noon on March 8th, 2024. To correct the violation, the respondent must pay the outstanding fees. If not corrected, a fine of $50 per day would be imposed until the violations are corrected. And as of today, the business tax receipt and the outstanding water bill has not been taken care of. And 3304 encompasses, this is out of the Brevard property appraiser site, encompasses the whole complex. The water is actually under 3310 for the address for the complex, and it's still showing an outstanding balance today.
Okay. And so water service has not been restored?
No, it has not, and it's occupied by two tenants.
Okay. I do see in the order that the $50 per day was imposed for the violation of 505.5 running water, not for the BTR.
Right, the BTR
So-
request was just for the fees for the BTR to be paid,
Okay.
the business tax receipt.
Okay, so you're not requesting any further
No,
fine
ma'am.
for that?
No, ma'am.
Okay. All right. Did you have anything else for me?
Not this time.
Okay, and the respondent is not
The
present?
respondent is not present, no.
Okay, all right, thank you. All right. I will find that respondent in this case failed to correct the violations by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code inspector. Respondent shall notify the code inspector to verify compliance. Thank you. All right, and for the record on that, so I have Exhibit 1 as the notice of hearing for this hearing, and then Exhibit 2 would be the PowerPoint presentation?
Yes, ma'am.
Okay. All right. Next case.
Yes, ma'am. This will start our initial hearing cases. The case is 24-09, Toby L. Smith, Eunice E. Smith at 2247 Country Club Drive, Titusville, Florida. Sections 1223, junk and debris. Mr. Smith's already came into compliance. And as of this meeting, 1373 inoperable vehicles has also been brought in compliance by proof of registration by Mr. Smith, who is present at the hearing.
Okay.
And with that, it'll be Officer Jim Flanagan to go forward with violations of 2058E parking.
Okay, I do have one question. So
ma'am.
for violations of 1223 and 13-73, did the respondent come into compliance prior to the time requested in the notice of violation?
Yes, ma'am.
Okay, perfect. All right, so essentially you're just asking to withdraw those.
Yes, ma'am.
All right. Go ahead.
Again, I have 3 exhibits for you today. It would be the affidavit and the notice of violation, the affidavit and notice of hearing, and the cost recovery affidavit for 26941.
Okay. Thank you.
Okay. Like we revised, the respondent, Toby and Eunice Smith, 2247 Country Club. The mail to address is the same, Titusville, Florida. And we're down to section 3, which would be the parking regulations. The other 2 have been corrected. This started on October 5th, 2023, where I noticed the violation and posted the property. Date given to comply was December 21st. A notice of respondent was mailed and certified, first class mailed on December 5th. A notice of hearing was posted at City Hall on the property on February 26, 2024, and it was mailed, first class and certified mailed on February 6, 2024. Basically, this started as during a proactive check of the area, observed several violations that included the junk and debris, the inoperable vehicles, and the oversized trailer over 14 feet on the side of the house. The junk and debris have been removed, and then as of today, the vehicles have all been taken care of. I am just going to zip through the pictures just so you see the trailer. This is the trailer that's parked on the side of the house. It's well over 14 feet. And this is the city code violations section. That states parking travel trailers, et cetera, of any length, cargo trailers, and not excess of 14 feet on the property. That's how it's listed.
Okay.
Okay. The vehicles. And again, the conclusion is basically the trailer over 14 feet in length is parked on the side of the property visible from the roadway.
And to be clear, so under this provision of the city code, if the trailer is over 14 feet, it cannot be parked anywhere on the residential property.
Correct.
Am I understanding that?
Yes,
Yes.
ma'am.
Okay, thank you.
No, I'm sorry, can you go back? Can you go back to the code that, okay, you asked if it was anywhere on the property, and the code does specify that the cargo trailers needs to be located behind the front building line.
Okay.
14 foot pertains to the front of the.
I'm sorry, sir, you have to wait until it's your turn to
Yeah,
speak.
yeah, no, but it's talking about cargo trailers not in excess of 14 feet. So if it was less than 14 feet, they are permitted to park on private property in a residential district as long as they meet those criteria.
Correct.
Right?
Correct,
So,
correct.
but in this case, the trailer is in excess of 14 feet and cannot be parked anywhere on the residential property.
Correct, I just wanted to make sure you knew those
Okay.
options.
Yeah, okay.
Yep. Sorry, I'm just trying to cut out the ones that I've already done.
Sure.
The recommendation be either remove the trailer from the property or put it in a view where we can't see it, basically. In order to respondent be assessed the administrative costs. If the respondent does not comply by April 5th, 2024, is requested a $50 per day violation be imposed each day until the violation continues, and to contact myself when it is corrected.
Okay, so you're asking for a compliance date of April 5th?
Yes.
Okay. All right. Was there anything else you have for me?
Not at this time, and the
Okay.
respondent is here.
Yes, sir, you can come forward. Can you state your name and address for the record, please?
Toby Smith, 2247 Country Club Drive,
Okay.
Titusville, Florida.
What would you like to tell me about your case?
Okay, in the codes, you have to read into the book farther that it says the 14-foot trailers cannot be only permitted on the frontage of your house on your driveway. If you read in farther, beyond the frontage of your house, it says it doesn't give how long the trailers can be as long as they're behind.
As long as they're behind what?
Behind the frontage of your house. You
Okay,
can't just read the one or two paragraphs. You got to go on farther. I have all the proof from 2006. I have 4 totes that Mr. Broom, the city attorney, knows all about. I went through this for 4 years because you can't discriminate against that recreational trailer, an RV, a fishing boat, an offshore boat, or a utility trailer that people use. Okay, they're all a purpose of hauling something, storing something, and it's all, I have all the proof. If I need to bring it in, I have 4 totes of 4 years of city council going through, proving all of the things that you can and cannot do. The code people that were in charge then are no longer in service. I knew this was going to happen when they changed code guys again, because we went through it 3 times. Mr. Broom will tell you, it was the longest City of Titusville code meeting in the history of Titusville. We went for 4 years because of a bad neighbor. I was cited for stuff that never should have been cited. So since 2006, my trailers have been either on the side of my house or in my driveway because I had 2 parking spots in my driveway. So everything I've been doing since 2006, I was fine with, didn't do anything. And in 2006, I rented a shop down off of Hopkins. Then zoning changed the zoning of no outside storage. So then I had to take my race trailers and move them back to the house, which still is in compliance on the side of my house, beyond the frontage, because there's RVs in this town, boat trailers in this town, offshore boats, guys' work trailers that are longer than 14 foot. I've got 250 pictures Sunday of people that got their stuff parked in their front yard. So the whole thing is, I've got 2,500 signatures that were brought in here in 2006. I will bring them back of all the hobbyists and the fishermen, everybody that has trailers in here, to get this resolved again.
okay, you've provided a lot of information.
Yes.
So let me break this down a little bit. The first thing I think you said was that you believe that there's a code section that allows for trailers that are 14 feet to be
Yes,
parked.
because they were only,
What code section are you referring to?
I would have to get all of my paperwork. My wife is like an attorney. She kept everything.
Okay, but this is the hearing today, so now is the
I
opportunity.
wanted to see what they came up with before we set another meeting for this, because I'm going to bring in these, at least 1,200 people to be in front of the magistrate and the code enforcement, that everything that went through, and you're going to have to watch probably 30 CDs that was made from the city back then of
So-
everything that we discussed that got cleared up, got interpretations gone. Mr. Broom can tell you all about it.
So, okay, again, today is the day of
Mm-hmm.
the hearing. We're not, it's not going to be something that we hear on a different day. Today's the day. So if there's any evidence that you want me to hear, now would be the time. However, I asked you a question, if there was a specific section that you wanted to point me to, but you don't recall.
I have not read that code book since we left this room in 2006 for that meeting. I have not had to go back over them codes because I knew that we were in compliance then. Everything got thrown out. That same trailer is still there from 2006.
Okay, so we just went over the code that
He pulled up one section.
correct, that specifically addresses trailers. I'm going to ask the Assistant City Attorney, do you have any responses you'd like to, or the code enforcement officers about that particular issue of whether there's another code section that would allow for a 14-foot trailer?
I would just like to comment on a couple of things that, yes, Mr. Smith has spoken to me in advance of this meeting. We did provide public records that he requested specific to this particular case to him, and he had an opportunity to ask questions regarding the code and the case of both my office and the code enforcement officers prior to this case, because we have communicated about this issue. The code section 20-58 miscellaneous parking regulation subsection E that is being cited today and being discussed has not been changed since 2009. It is my understanding that there was lengthy city council meetings that discussed changing that particular code section, but it was not changed. And at the end of the day, there may have been lengthy council meetings, but if the code wasn't changed, then it remains the current code that any cargo trailers over 14 feet in length are prohibited. Now, it was Mr. Broom that was present at that time. The dispute predated my appearance here at the city of Titusville. So based on that, long time ago history, we do not have any documentation to the contrary. And we asked Mr. Smith to provide any documentation because, as he's told you, he told us that he had boxes of papers that said something to the contrary that I have not seen.
Okay. All right. So essentially, you believe that there may have been city council discussions about changing the ordinance, but that didn't take place.
There was no change that ever came to fruition that's resulted in this code being any different from what you've seen today. And that probably existed at the time where Mr. Smith was previously cited, but the city is going to continue to move forward with this case because the code does not allow cargo trailers over 14 feet in length.
Right, and we just went through that. So, all right, the other thing I heard you say, what Mr. Smith, was that I think you said you've had trailers there since 2006, but then you
Actually, my
removed
trailers
them?
have been there since probably 99.
Okay,
And that's when we got from code board, when the board was still here, there was no magistrate, that everything got clarified. Nothing had to get changed. It got clarified. It was supposed to get written to what it said about the frontage of the house, that the trailers could only be a certain length on the frontage of the property, and from behind the frontage of the property, nobody could tell you how long they could be. That right now, I'll guarantee you there is 30, 28, 24 in cargo trailers sitting in people's backyards right now. So what you're telling me is if you're not allowed over 14 foot on your property, you also have to tell me that nobody with an RV, nobody with a camper, nobody with a boat, work trailer, or a utility trailer can be on their property. That, and we had this taken care of in 2006, was clarification on all of this. And I guess it wasn't written, and Mr. Broom says he doesn't exactly know what happened. And I didn't follow it after that. So if what I got to do again is not be in compliance with my trailer, start this all over with the city of Titusville again, I guess I'll pull out all my paperwork and make my phone calls from all the people that I went to their houses, got their phone numbers, and they came up here and sat for that 9-hour meeting up here, and we'll do this again to get this clarification done again, because there's people in this town that have 30-foot RVs sitting in their yards. They got 20-foot the food trailers sitting in their front yards. They got their boats sitting in their front yards. My stuff my long trailer is behind the frontage of my house. You know, it's like starting a war all over again with the citizens of Titusville.
Would you do me a favor and put the code section back up on the screen? Is that possible?
And when you go through the codes, when you read, you have to go to, there's like 7 sections that read the interpretations and clarifications of stuff. It's not just that one page where it says a 14-foot. Mr. Broom, I sat down with him for over 2 weeks coming in and out of his office, finding all this stuff that my wife found, and I showed it to him. That's the only reason that I'm upset about this. It was all taken care of in 2006. And my wife's the type that she keeps all of her paperwork. She doesn't throw anything away.
Okay, give me a moment. I want to look at the code section here.
And don't take me wrong, I'm not upset with all of y'all because nobody was here back then. And believe me, it took my wife months to find all the clarifications on it. That's why I say, I pity your job because I know what you got to go through because I know the code book in and out.
But I did want to share with you, though, that all of that you're talking about, this would not be the platform for that. That would
Okay,
be
but if I'm
the
up here and
council.
I'm getting cited now for it,
That's right.
and
But like I said, though, the magistrate can't change the code, can't alter the code.
I understand that's
So,
not her,
just
but
so you know.
how do we go through to take care of this?
Well,
City
I-
council is the
after
only
meeting,
body.
I'll be happy to sit with you.
Broom told me there's no more city council.
No.
I mean,
Let's
code
let's
board.
get this done and let the magistrate do what she needs to do to get it going.
Mhm.
And then I'll be happy to sit with you and explain where you need to go from here.
Okay,
And the consequences of where that would lie.
yeah, because right now
So,
with,
but this is not the purview for her
I
as
understand.
a hearing officer.
Okay, and so that
you
this,
just need to let-
this should be just held
Well,
until I meet with the city
Well-
council.
Well, we can work all that out. That's like I said, let's let the magistrate do the hearing today. And I'll be happy to sit with you after the hearing or tomorrow or whatever you'd like.
Okay, so I think one thing that clarifies this issue is under section also 20-58, but it's not up on the screen. Subsection A states that there shall be no off-street parking in the front yards, rear yards, and side yards. I'm sorry, yeah, no off-street parking in the front yards, rear yards, and side yards, street side of single-family dwellings except as normally exists in driveways or designated parking spaces unless otherwise provided in this section. So subsection A is telling me, unless it's otherwise permitted in this section, it's prohibited. And what is listed here under subsection E is that only cargo trailers that are less than 14 feet may be parked on residential property in certain areas. And the testimony has been that the cargo trailer that you have is in excess of 14 feet. So so I understand that there may be some, as was stated, that there may be some desire or there had been discussion by the city council to change this section, but as was stated, I'm here to determine the case based on the laws that is currently written.
I understand.
So, all right. Let me just check my notes here really quickly.
as
Okay.
you see on that one picture. I also went and got a permit per code enforcement, per city council, to put a drive on the other side of my house to park that trailer on. So I spent the money for the concrete company come out there, got my permit, which is on file, to pour that driveway, got it inspected for the purpose of parking the trailer over there.
A permitted driveway does not allow unpermitted vehicles to be parked on it.
We'll talk later.
Okay, all right, I have to agree with that. I mean, simply because a permit was issued to pour a driveway doesn't necessarily mean it was issued for the purpose of allowing that
understand.
particular type of vehicle to park there. So, all right, sir, did you have anything else before I make my ruling?
No, that's it.
Okay.
I just wanted you to understand what went on and what's going to go on in this town again.
Okay, understood, thank you. All right, I'm gonna go ahead and make my ruling.
Thank you.
All right. I find respondent in this case in violation of the city code as charged with respect to section 20-58E. And that respondent correct the violation before 12 o'clock PM on April 5th. In the event respondent does not comply by the state, a fine in the amount of $50 per day will be imposed for each day that the violation continues past the aforestated date. Respondent is further ordered to contact the code inspector to verify compliance with this order. I find that the notices were properly given in this case, and in terms of exhibits, I have 4 exhibits. I have the Exhibit 1, which was the affidavit and notice of violation, 2, which was the affidavit and notice of hearing, 3, the cost recovery sheet, and 4, which was the PowerPoint. And I'm going to further order that the cost of prosecution be paid in this case. Was there anything else from the city? Was there anything else from the city that you needed on this case?
No, ma'am.
Okay. All right. I believe that is it, and unless we have anything else, we can adjourn.
No, ma'am.
All right, we'll go ahead and adjourn. Thank you.
And thank